Podcast is now starting. All attendees are in listen-only mode.
Hello, this is Nicole Mace, Executive Director of the Vermont School Boards Association. This video is intended to provide school board members and superintendents information regarding the Act 46 Final State Plan timelines and default articles of agreement. On November 30th, in accordance with the deadline provided to the State Board through Act 46, the Vermont State Board of Education issued its final report of decisions and order on statewide school district merger decisions. The final report includes default articles of agreement for each new union school district that has been formed by the final report. The default articles will govern the new union school district unless and until the district amends them. And this presentation is designed to give you information about that process. There are some immediate tasks for districts that have been ordered to merge under the state plan. The first is that each member district of the merged district must appoint 2 members to sit on a transitional board. The default is the chair and the clerk of each board, unless other members are selected by a majority of the board. In addition to appointing members to the transitional board, the superintendent also must work with the Secretary of Education to draft the warning for and to warn the organizational meeting of the merged district. The Agency of Education has developed template warnings for your consideration and use. Donna Russo-Savage at the agency can send those to you or your superintendent. The meeting must be warned between 30 and 40 days in advance. And there is a that means that there's a December 28th deadline to warn the organizational meeting because the meeting must be held by January 29th. At the organizational meeting, there is a lot of business to be conducted per statute, but the main business of the meeting includes swearing in the transitional board members and allowing voters to decide if budgets will be voted by Australian ballot and if elections will occur by Australian ballot. It's important to remember that this organization meeting is not an organization meeting of the board, it's an organization meeting of the voters in the district, which includes all member towns within the merged district. Once you hold the organizational meeting, the first meeting of the transitional board must be called within 14 days of that meeting. It can occur on the same day as the organizational meeting. So if it's easier to hold the first meeting immediately following the organizational meeting, that's an option available to you. At that first meeting of the board chair and clerk must be elected. Some other immediate tasks that board members need to consider include amending the default articles of agreement. So the boards of the merged district must first review the default articles and then decide whether to form an amendment committee to make changes to the default articles of agreement. This process was created as part of Act 49 of 2017. Composition of the amendment committee must be proportional based on equalized pupils, similar to 706B committees, and at least one of the members appointed by each board must be a current school board member. Any amendments to the articles, and there are some limitations on which articles can be amended, which we'll get to later, but any amendments that are proposed by the committee must be approved by the full electorate of the new merged district on or before February 28th, 2019. And that again is a deadline established by Act 49. These changes are for articles that board members or the amendment committee want to have be in place on the date the new district becomes effective, which is July 1, 2019. If you want to make changes to the articles prior to the district's operational date, they must be approved by the electorate by February 28th. So in the meantime, well, there may be an amendment committee meeting. There's also a transitional board, and they have some responsibilities, which include warning a special meeting of the voters to consider whether to amend the default articles if you have a committee and the committee recommends making some changes. The transitional board is also responsible to warn a special meeting of the voters to elect their initial members of the merged district board. Prepare a first draft of the budget to provide to the new district board at their first meeting, and perform any other duties required to facilitate the transition to the new district that must occur before the new merged district board is elected. And again, just to reiterate, here are the votes required by July 1, 2019. If there is a proposal to amend the default articles of agreement, which is optional, that must be done by February 28th. There must also be a meeting to elect the members of the merged district board. There's also must be a subsequent meeting once the merged district board has been formed to approve a budget. And their agency is recommending that that occur no later than May 1st, 2019, in order to allow for, in the event a budget does not pass, or for the reconsideration period to expire, that occur before May 1st. And each of these votes must be preceded, per Vermont law, by a 30 to 40 day warning period. So it's very important for merged district boards and transitional boards to start to chart out the timeline, because it is a very tight timeline to warn some of these meetings. So now I'm going to transition to an overview of the default articles of agreement. We're actually going to go article by article. We're basing this summary on the articles for the Windham Southeast Supervisory Union. And I just want to note that there are 3 differences depending on the structure of the districts involved. So there are Union Elementary districts that have been ordered to merge under the final plan, so that would be a pre-K through 6 or a pre-K through 8, and then there are pre-K through 12 districts. So there may be some differences depending on the type of district that's being formed. There's some differences on Article 6 regarding future sale of a school district building if one of the forming districts is a union school district. And then there's some differences depending on whether or not a new unified district is going to be designated as a supervisory district or whether it will continue to be part of a supervisory union. So just want to note that there are some variations in the articles, but generally speaking, with those exceptions, the provisions are identical. So Article 1 creates the new district, and it includes the list of what's called the forming districts. So the member districts that are going to be forming into the new union district. It has a temporary legal name for the new district and a list of the resident students. Obviously, the details of that article will be different for every district. Article 2 specifies the grades that will be operated and or tuitioned in academic years 2019-20 and 2020-21. Article 3 covers attendance at schools in those 2 academic years and whether grades can be restructured. In general, for those first 2 years of operation of the new district, each student in grades for which the new union district operates multiple school buildings will continue to attend the school a student residing in that town would have attended in this school year. So there's an attempt to ensure some continuity for students in the first 2 years of operation in the new union school district. Restructuring grade configurations is not allowed for the first 2 years of operation. And this means eliminating classrooms for any grade or grades operated at one or more schools and requiring children in that grade or grades to attend classes located in a different school. So, you know, converting a K-6 school into a K-3 school and sending 4 through 6 students somewhere else, and vice versa, is not allowed within the first 2 years under these default articles. Article 4 deals with the closure of buildings, and it separates this article into 2 time periods. The first time period is the first 2 years, and the second is academic year 2021-22 and beyond. So in the first 2 years of operation, the new district shall not close any school building that was conveyed to it by a forming district, or stop using a building to provide education in at least one grade unless the voters in the town in which the school is located first approve closure of that school. In the years 2021-22 and beyond, the new Union School District Board may not close any school unless first approved by the electorate of the new Union District. So in the first instance, the town where the school is located must approve closure. In the second instance, the electorate of the entire district must approve closure. Article 5 covers indebtedness, including capital debt, operating fund surpluses, and transfer of debt and funds. So related to indebtedness, the article requires a new district to assume all indebtedness that exists on June 30th, including capital debt of all the forming districts. The new district also assumes all operating surpluses, deficits, and fund balances of the forming districts that exist at the close of business on June 30th. The new district is required to apply any reserve fund for the fund's specific purpose, if identified, unless otherwise determined through appropriate legal procedures. So if it was a capital reserve fund, then the new district is required to apply those funds toward capital improvements. And if it's clear that those capital improvements are dedicated to a specific building, then they would be obligated to apply the reserve fund for that purpose. The forming district must transfer the debt and funds specified earlier in the article to the new Union District on or before June 30th. And the new district board will establish procedures and timelines for that transfer to be accomplished in that time frame. Article 6 covers real and personal property, including the transfer of real and personal property to the new district, the subsequent sale of any property to a town in which it's located in any year in the future, and the subsequent sale of real property conveyed by the forming district that was a union district in any year in the future. And again, this is one of those articles where there will be some variation depending on whether there's a union district involved. So with respect to transfer of property, Article 6 requires the forming districts to convey to the new district for the sum of $1 and subject to whatever encumbrances on the property exist in its recording and are recorded, all their school-related real and personal property, including all land, building, and contents. Subject to the prohibitions or requirements related to closing a school building that are in Article 4, if the new Union District Board determines that the property that was conveyed to it by one or more of the forming districts will not be used to provide education in at least one grade or for any other purpose related to the operation of the district, then the new district has to offer it back to the town in which the property is located. Any sale to the town under those conditions is subject to the following requirements. It must be conveyed back to the town for the sum of $1. Again, all recorded encumbrances will be transferred back with the property. The town will assume or pay all outstanding bonds or notes. Repayment of any school construction aid or grants, and the conveyance is conditioned upon the town using the property for community and public purposes for a minimum of 5 years. If the town elects to sell the building prior to 5 years of ownership, then the town must compensate the new district for all capital improvements and renovations initiated after July 1, 2019 and prior to the sale to the town. If the town elects not to acquire ownership of the school building in all likelihood, then the new district must sell the property pursuant to current law and upon such terms and conditions that are established by the new board. And essentially, the electorate must approve the sale of school property within a district under Vermont statute. So, notwithstanding all of that, and subject to the school building closure requirements in Article 4, if the new Union District Board determines that the building that was conveyed to it by a forming district that was a union district, and again, this is specific to merged districts that included union districts, and it will not be used for delivery of education in at least one grade or for any other purpose related to the operation of the new district, then the new district shall sell the property pursuant to Vermont statutes. Okay, so Article 7 deals with contracts. In the first year of operation, this article requires the new district to provide transportation, assignment of staff, and implementation of curriculum in a manner that is consistent with the contracts, collective bargaining agreements, and provisions of law that are in effect during that academic year. The new district must comply with state law regarding recognition of representatives of employees of the forming districts and the supervisory union, if that is applicable. That has been the law for several years now, in that a new district must immediately recognize the representatives of employees without requiring employees to go through the process of forming a new union and electing new representation. In the absence of new collective bargaining agreements on July 1, 2019, the new district complies with pre-existing master agreements. So I believe most districts are in the process of negotiating for agreements to take effect July 1, 2019. So this is an appropriate opportunity to consult with legal counsel to determine whether or not this process should include negotiations for how to bring multiple agreements together. There's a lot to be done in a pretty tight time frame, so the law and correspondingly this article recognizes that it may not be possible to negotiate a new agreement by July 1, and if that is the case, the new district is obligated to assume all pre-existing master agreements and comply with those. The new district must also honor individual employment contracts that are in place in the forming districts on June 30th until their termination dates. If a forming district enters into a contract on or after November 1, 2018, then this paragraph applies only if the contract expires on or before July 1, 2020. Article 8 provides more detail about the organizational meeting that I referenced in the beginning of this presentation. As I noted then, it requires voters to hold that organizational meeting on or before January 29th. The superintendent is responsible for posting notice of the date, time, and place of the meeting in at least one public place in each town within the new merged district, and to publish it at least once in a newspaper. Again, the 30 to 40-day window requirement exists here, as it does for any special or annual meeting of the school district electorate. The Secretary of Education will draw the warning for the organizational meeting, and this is because there is no transitional board that's been sworn in at this point in order to warn the meeting. So under Vermont law, it's the Secretary's responsibility to do so. The Secretary or his or her designee will call the organizational meeting to order, and the voters of the new Union District transact the following business. Elect a temporary presiding officer and a clerk of the district, and that's an elections clerk, not a board clerk. Swear in the members of the transitional board. Adopt Robert's rules or other rules of order for governing the conduct of the meetings of the electorate. Elect officers of the new district, so a moderator, a clerk, and a treasurer. Determine the date and location for the first annual meeting of the district and all subsequent annual meetings, which cannot be earlier than February 1 or later than June 1. Determine whether to vote on the budget and all other public questions by Australian ballot. Determine whether to elect members of the board by Australian ballot. Determine and approve compensation, if any, to be paid to board members. Establish provisions for the payment of any expense incurred by the new Union District before it becomes fully operational on July 1. Authorize the new Union District to borrow money pending receipt of payments from the State Education Fund by issuance of notes or orders payable. And finally, determine whether to authorize the school board to provide notice of the annual report in lieu of actually distributing the annual report and budget, much like exists for school boards, and address any other business that's determined to be necessary and advisable. So then Article 9 speaks in greater detail to the transitional board. And again, this is somewhat repetitive of the slides I reviewed early on, but this is where that information comes from, the default articles. So the transitional board will be comprised of the chair and clerk of the board of each forming district, unless a majority of the board of a forming district designates another member or members to serve on the transitional board. Those transitional board members will serve until the voters of the new Union District elect members of their initial board of directors that's set forth as set forth in the process under Article 10. The superintendent of the supervisory union, in which the majority of the forming districts are members, must convene the first meeting of the transitional board no later than 14 days after the organizational meeting. And as I noted in the outset of this presentation, you could hold that meeting on the first, on the same day as the organizational meeting immediately following. The agenda of the first meeting of the transitional board includes the election of the chair and the clerk of the board. The purpose and authority of the transitional board I reviewed earlier, and it's laid out here in Article 9. So Article 10 speaks to the representation on the new Union District Board, and this is the district board that is elected by the voters in the new merged district. The composition of the board follows the hybrid model of board representation. So the United States Constitution requires proportional representation on elected bodies. The hybrid model has been endorsed by the United States District Court for the District of Vermont as meeting the constitutional requirements of proportionality. The hybrid model essentially allocates the same number of seats to every town within a forming district, irrespective of the size of that town. So under Article 10, every forming district has 2 seats on the board. The way it satisfies the constitutional requirement is that every voter within the new district votes on the entire new Union District Board. So while you have seats allocated to specific towns, all the voters in the district elect the board members. Article 10 specifies the length of term for the initial board members and election processes if voters decide at the organizational meeting to proceed by Australian ballot. And again, within 14 days after the initial board members are elected, the superintendent has to arrange for their swearing in by the clerk of the district or a town clerk within the district and convene the first meeting of the new board. At that point, the transitional board dissolves, and the new board elects a chair and a clerk. And at that first meeting of the new board, the members of the transitional board present their draft fiscal year 2020 budget, along with any supporting data or information they believe is important for the new board to consider as they review the proposed budget. That board then takes the budget and gets it to a place where it's ready to propose an FY 2020 budget to the voters of the new district. And then it's in the hands of the voters to approve and appropriate sums of money that are necessary to meet the district's expenses. And how that vote is conducted in terms of whether it is Australian ballot or from the floor is again a decision that is made earlier on at the organizational meeting for the district. Article 11 speaks to representation on the new board on or after the new district's annual meeting in 2020. So they'll continue to be composed of individuals elected under the hybrid model, unless and until the voters of the new district amend Article 11. So the law requires staggered terms. So the terms of the initial board members are outlined in Article 10B for the initial terms, but moving forward, each member serves for 3 years or until his or her successor is elected and qualified. Each member of the new union board who serves after the expiration of the terms has to be elected at an annual or special meeting of the new union district. The terms of office begin and expire on the date of the district's annual meeting, much like the case today. If the voters amend Article 11, the amendment must ensure that the terms of office are staggered as required by law. So you don't have all 10 members of a board of directors have their terms expire at the same time. Article 12 talks about when the district will begin to operate. So it provides the new Union District Board with the authority to take all actions that are necessary for it to prepare for full educational operations beginning July 1, 2019. That includes adoption of policy, negotiation of contracts, preparation of the budget, etc., much of which we've reviewed earlier in the presentation. On or before June 30th, the new board has to conclude and perform all planning, transitional, and other related duties that are necessary in order to begin operations of the new district. However, each forming district remains responsible for educating its resident students until July 1, 2019. So even though you'll have a new district board that exists and is meeting and planning for the assumption of educational operations, those responsibilities starting July 1, each of the member district boards will remain in place and responsible for educating their students until July 1. Article 13 deals with the dissolution of forming districts. So on July 1, when the new district becomes fully operational and responsible for providing for the education of resident students, the forming districts shall cease all educational operations. Those forming districts may remain in existence for no more than 6 months for the sole purpose of completing audits or any other task the new district is legally unable to perform. They cease to exist once that business is completed, or December 30th, 2019, whichever is earlier. Each new district, union district that is not a supervisory district, is assigned to a supervisory union. There's been some shifting of districts to new supervisory unions in this plan. But if the new union district is designated as a supervisory district, then for the transitional period, that union district will still be assigned to a supervisory union. So by way of example, under the articles or the state plan, Washington Central Unified Union School District will be a supervisory district on July 1, but until then, those districts will still be assigned to the Washington Central Supervisory Union so that they can still access services that are provided through the central office during the transition period. Article 14 lays out the authority to amend articles. So if you have a committee that's been formed to look at the articles and propose amendments to them, be sure that they are well familiar with Article 14, which provides a list of articles that cannot be amended by the electorate of the new district, the elected board of the new district, the transitional board, or the electorate or board of any forming district except as expressly authorized by the General Assembly. It clarifies which articles can be amended only by a majority of the voters in the new union district. It provides a list of articles that can be amended only if approved by the voters of each town identified in the articles or as part of the forming districts, and provides a list of articles that can be amended by the board of the new union district, provided, however, that the board may present questions to the voters either in the board's discretion or upon a petition of the voters, as is the case under current law. There's also a process in place for amending. I again reviewed much of this earlier on in the presentation, but if you want to amend the articles in advance of July 1, in particular, articles relating to composition of the board of directors, those amendments must be presented on or before February 29th at a meeting of the electorate. That is not a lot of time. You essentially have 90 days from the issuance of the plan to form a committee, draft the articles of agreement, hold at least one public hearing, take public comments, maybe make some modifications, and then warn a vote with a 30 to 40 day window and hold that vote. If you are interested in amending the articles later than February 28th, you have to follow a process that's outlined in Title 16. So if you want articles to be amended after the district becomes operational, there are provisions under state law that allow for that to happen, and so the articles then defer to state law. So that concludes an overview of the articles that are in the default Articles of Agreement issued by the State Board. I just wanted to spend a couple minutes touching on the question of anticipated litigation. We are aware that there are many school districts, boards that have that are in the process of exploring the possibility of filing a lawsuit against the state of Vermont. That status is unknown to me at this time. So it's important that you consult with your district's attorney regarding the best course of action on behalf of your district. Now that the state plan is out and the default articles are out, it is critical that you seek legal guidance regarding what next steps to take. I want to urge districts that sign on to the lawsuit to consider also taking steps to comply with the requirements set forth in state law and the default articles of agreement, and not just put all your stock in the outcome of an uncertain litigation process. And failing to do so means more uncertainty for district employees, parents, and students, and frankly, less and less time to think through issues that are important to the operation of your district and take action to make decisions that matter to many of you and your constituents. Recognize that this is a heavy lift in a short period of time. There are some resources to support your work. Donna Russo-Savage at the Agency of Education is as familiar with the details of the articles and the requirements of the law as anybody, and can respond to questions quickly, because many questions she's already responded to. So I always urge folks to start with Donna if you have a question about anything that's in the articles or the state plan. We have had a couple of Act 46 implementation project consultants let us know that they're available to support districts who want to form an article amendment committee. These are folks that have helped districts draft articles of agreement, so they're familiar with the content of articles and can be available on a limited basis. There are no state funds available to pay them, but if your district finds that some external support would be important in order to meet some deadlines, please let me know. And then myself and Sue Suglowski, our Director of Legal and Policy Services, are always available to answer questions, and if we don't have the answers ourselves, we can track them down for you and work with our other legal and state agency partners to determine what the answers are or what the guidance can be to support this work moving forward. So thank you for taking the time to listen to this presentation. Please feel free to reach out to me with any questions. Thanks again.